Okay, you've made it. You navigated the whole patent examination maze, you fought the good fight, and now you've got it, the notice of allowance from the USPTO. Feels like victory, right?
It absolutely does. But hold on, there's one last step. It's purely administrative, but absolutely critical.
Right. Miss this one checkbox, this one deadline, and the whole thing can just disappear. Poof. Abandoned.
Exactly. This isn't about arguing patentability anymore. It's all about flawless execution. Think of it like the administrative finish line.
So our deep dive today is zeroing in on MPEP Chapter 1300, specifically Section 1306. That's all about paying the issue fee.
And for you, the learner, this is vital because paying attention here, getting these details right, is literally the difference between getting your patent granted and having it vanish into thin air.
It really sounds like the final hurdle, governed by some pretty unforgiving rules. So let's break it down. What exactly are the rules for paying this issue fee and making sure that patent actually issues?
Okay, the core mechanics are, well, they're strict and statutory. Once you get that notice of allowance in the mail, the issue fee, and any publication fee if that applies, it's due within 3 months.
3 months from the mail date of the notice.
Correct, 3 months exactly. And the notice itself should spell out precisely what fees are due. It'll even reflect, if you qualify for small entity status, that's a 60% discount, or micro entity, which gets you 80% off.
Now, we always talk about extensions of time in patent prosecution. You can usually get more time for responding to office actions, filing an RCE. Is there any flexibility here with the issue fee deadline?
And this is the absolute key takeaway. No, there is zero flexibility. The director has no authority to extend the time for paying the issue fee.
Not at all.
None. It's baked into the law, 35 U.S.C. 151. It's an absolute deadline. And what's more, if you intentionally don't pay the fee within those 3 months, well, the MPP is very clear. That failure cannot be used later as a basis for reviving the application claiming unintentional delay.
Wow. Okay, that's huge. So you can't just, strategically let it lapse, thinking you can revive it later if your plans change.
Yeah.
The usual safety net for unintentional mistakes doesn't apply here if the non-payment looks deliberate.
Precisely. The USPTO treats this deadline as completely non-negotiable. Now, practically speaking, who can actually pay this fee?
Good question.
The office will accept it from the applicant themselves, or the assignee if there is one, or a registered patent attorney or agent. That could be the attorney officially on record, or even one acting in a representative capacity under Rule 1.34.
And how do you actually make the payment?
Typically, you'll use the fee transmittal form, that's PTO A85B, or you can use an authorized USPTO deposit account or a credit card through their systems.
Okay, let's talk about those deposit accounts. They can be tricky sometimes. What if, say, an attorney fills out the PTOL 85B, authorizes the charge, lists the right fee amount, but forgets to check one of those little authorization boxes on the form? Is the application dead?
That's a really practical scenario. And thankfully, the MPP provides a bit of administrative grace there. As long as the fee amount is right and there's a clear authorization to charge that specific deposit account, the USPTO will generally go ahead and charge the fee.
Okay. So the intent to pay is usually honored even with a minor slip-up like a missed checkbox.
Generally, yes. But, you really shouldn't rely on that. Best practice is always double-check everything on the form.
Makes sense. Now, another potential complexity, reapplying fees. Let's say an applicant pays the issue fee, but then the application gets withdrawn from issue for some reason. Maybe they need to file an RCE. Then later they get another notice of allowance. What happens to that money they already paid?
Right. Good scenario. They absolutely can get credit for that first payment, but it's not automatic.
Okay.
If the application was withdrawn after the fee was paid, and then it becomes allowable again, maybe after that RCE or some other continued prosecution, you have to file a specific request.
A request to do what?
A request asking the USPTO to reapply the issue fee that was previously paid towards the issue fee that's now due again on the same application.
Got it. So you have to explicitly ask for it, otherwise you might end up paying twice?
Exactly. It saves you paying again, but you have to flag it for them.
All right, so payment must be on time, deadline's absolute. But what if you need to delay the actual date the patent grants? Maybe there's a last-minute business deal or some complex international coordination. Can you pause?
Yes, there is a mechanism, but it's important to understand this is about deferring the issuance date, not the payment deadline. You still have to pay the issue fee within that 3-month window.
Okay, so payment is locked in, but you can ask them to hold off on actually printing the patent.
Correct. Normally, after you pay the fee, the patent issues pretty quickly in the regular course of things. To stop that, you either need the application withdrawn, which we just touched on, or you need to get a deferral granted under Rule 1.314.
And getting that deferral, I imagine it's not easy. What's the process?
It's not automatic, no. You have to file a formal petition specifically asking for deferral. That petition needs its own fee, the one listed in Rule 1.1 ch, and crucially, you need to provide a showing of good and sufficient reasons why you need the delay.
Good and sufficient reasons. What does that actually mean in practice? People might want to delay for all sorts of commercial reasons.
Yeah, and the MPP is pretty restrictive here. This deferral is generally only for truly extraordinary circumstances. And even then, they typically only grant it for about a month maximum.
So what's not considered extraordinary?
Things like just needing more time for routine admin tasks, or wanting to finish negotiating a license agreement, or even trying to line up your foreign filing dates. The office doesn't generally see those as good enough reasons. It's really meant for unforeseen, significant administrative hiccups.
Okay, so it's a very high bar. Don't count on getting a deferral easily. Now, switching gears slightly, what about withdrawal? If the office pulls the application back from issue after the fee's been paid, say they find an error or something, how is that handled?
That's a serious step, pulling back an allowed, paid-up application. Any notice doing that has to clearly state which specific statutory condition allows the withdrawal, and the review process is interesting.
How so?
If you want to challenge the Technology Center director's decision to withdraw the application, your petition doesn't just go back to them, it gets escalated.
To who?
It goes up to the Deputy Commissioner for Patents who oversees the Office of Petitions.
Wow. That definitely signals how seriously the office takes messing with an application at this very final stage. Elevating review like that means it's not just some minor clerical fix. It's a significant administrative decision.
Absolutely. It shows the gravity attached once that issue fee is paid.
Okay, let's move into the final stages then. Coordinating multiple related patents and what happens right after you pay.
Right.
Section 1306.02 mentions simultaneous issuance. Why would someone want multiple patents to issue on the very same day?
It usually comes down to business strategy. Imagine you have a main patent and maybe a continuation or a divisional covering slightly different aspects of the same product. You might want them all to become enforceable at the exact same moment, perhaps for a product launch or licensing or an enforcement campaign. It synchronizes everything.
Okay, that makes sense strategically. But it sounds like a logistical headache for the patent office. What are the requirements?
It is a significant administrative task for them, and they won't grant the request unless all the applications you want synchronized are already allowed and have had their notice of allowance issued and the fee paid.
So everything has to be lined up perfectly beforehand.
Exactly. And you need to submit a very specific request. It has to list all the application numbers, the filing dates, inventor names, titles of the inventions, the dates they were allowed, just a ton of detail.
And you need that for every application involved.
Yes, and critically, you need to attach a separate copy of this detailed request to each individual fee transmittal form, the PTOL 85B, when you pay the issue fee for each application. Miss one detail or forget one copy, and the synchronization probably won't happen.
Wow. Okay, administrative perfection needed there across multiple files. So let's say you've paid the fee, maybe requested simultaneous issue, maybe not. What happens next? Section 1306.03 covers practice after payment. What should you be looking for?
Right. Once that fee is processed, the application is basically in the queue for final publication. Patents issue electronically now, and it happens very reliably on Tuesdays.
Every Tuesday?
Pretty much, yeah. And the key document for the applicant at this point is the issue notification.
When does that come out? How do you know the patent is definitely issuing on a specific Tuesday?
The issue notification usually becomes available electronically, typically through Patent Center on the Wednesday or Thursday before the Tuesday it's scheduled to issue.
Okay, so you get a few days heads up.
Exactly. That notification is the final confirmation. It has the patent number and the issue date. So you really need to be monitoring your application status diligently around this time, or make sure you're signed up for the eOffice Action Program so you get those alerts.
Makes sense. What about filing things after you've paid the issue fee but before the patent issues?
Yeah.
Like if you spot a typo or need to file some minor correction.
The MPP strongly advises against it, unless absolutely necessary. You really want to minimize any filings during this very last stage.
Why is that?
Because once the fee is paid and it's scheduled for issue, the administrative process is largely automated. Any new paper you file, even something small, can potentially disrupt that process and cause delays in issuance.
So it could actually postpone your patent grant date.
It could. And the rules even mention that filing duplicate papers or unnecessary documents during this window might be seen as not engaging in reasonable prosecution efforts. Basically, pay the fee, then try to leave it alone unless something truly critical comes up. Hashtag tech tag outro.
So listening to all this, it really hammers home why that issue fee stage is called the final hurdle. The absolute number one takeaway seems to be the finality of that 3-month payment deadline.
Absolutely. No extensions from the director, no wiggle room. It's set by statute.
And understanding that is just crucial for you, the learner.
Right.
Because as we discussed, deliberately not paying that fee isn't something you can easily undo later with an oops, it was unintentional argument.
Right. The USPTO essentially cuts off that path for the issue fee. The burden is entirely on you, the applicant, or your representative to get that payment in correctly and on time. It makes this final step incredibly high stakes.
It really does. So here's something to think about. Given that the director can't extend the deadline, and knowing that administrative errors or, mail delays or payment system glitches can happen, how could a patent owner proactively guard against disaster in this final window?
Yeah, that's a good question. Maybe thinking about things like redundant payment reminders or even having backup payment methods authorized well before the deadline actually approaches. Things to consider.
Definitely food for thought.
We would like to extend a special thank you to Mike Shepard, the creative director who organized this entire audio series.
Disclaimer. This summary of the MPEP was generated using AI tools, including ChatGPT and NotebookLM, and may contain errors or omissions. It is provided for general educational and informational purposes only and is not legal advice or a substitute for formal instruction. For authoritative guidance, consult the official MPEP, a qualified instructor, or registered patent practitioner.